The Supreme Court of Texas. All persons having business before the Honorable, the Supreme Court of Texas, are admonished to draw near and give their attention, for the court is now sitting. God save the state of Texas and this honorable court.
Please be seated. We'll hear argument in three cases this morning. First is 22-291, Texas State University against Tanner from Hays County and the Third Court of Appeals District. Then 22-308, Image API versus Young from Travis County and the Seventh Court of Appeals District. And finally, 22-431, Union Pacific Railroad against Prado from LaSalle County and the Fourth Court of Appeals District. The court has allotted 20 minutes for each side in each of the arguments, and we'll take a brief break between the arguments, completing them this morning before lunch. The arguments are being webcast live this morning and will be available in the court's archives later on. Justice Devine cannot be present this morning, but expects to participate in the decisions of all three cases. We're ready for argument in 22-291.
May it please the court, Ms. Cherry will present argument for the petitioner. Petitioner has reserved 5 minutes for rebuttal.
I have a medical tremor, so you might see that in my movements or hear it in my voice. This court has long held that the state only consents to suit in the means and the manner in which the legislature prescribes. Here, the state did not consent to suit the state did not consent to receiving service nearly 4 years after the lapse of the statute of limitations. The easiest way to go through this case, which has a lot of twists and turns, is to look at two cases. One is Chatha, and the second one is Pollux v. Wells. So if you look at Chatha, this court found three components to the terms or the requirements of 31134. The first component is that the requirement has to be in the statute. Here, diligence service is within the statute. It's both in 16003 implicitly, and it's explicitly in 101-102 of the TCA. Second, it has to be a requirement. And you can also see that because in both 16003 and 101.102, the legislature uses the word must, and must, pursuant to the government code, is a condition precedent. The third requirement is that diligence service be a prerequisite to suit. As Chatha explained, the statute of limitations is a prerequisite to suit because it is something that needs to be done prior to bringing suit. If you
said filing, didn't it? The term pre indicates the requirement must be met before the lawsuit is filed. That's what Chatha says.
Yes, Your Honor. And when you file a lawsuit, as this court has held in Pollux v. Wells and Gant v. DeLeon, you have to not only file a petition, but you also have to serve the other party.
I thought that was bringing suit. Bringing suit includes filing and service.
Well, I think it's fair to say that bringing suit and filing a lawsuit are similar because the court could have said filing a petition, but moreover, 16003 says bring suit. And as does 31134. It's not about filing a petition.
So why shouldn't suit mean the same thing in 16003 and in 311034?
I'm sorry, can you repeat the first part?
Yeah, so suit, you're focusing on the language of bring suit in 16003 and saying that that includes service as well as actually filing a petition. And if that's right, then why doesn't suit have that same meaning in 311034?
I do think that suit could have that meaning
And if
too.
it does, then if suit in 311034 means filing and service, then service is not something that happens before suit.
Service happens before suit. It does not. It happens at the same time that you file the petition. Now this is.
But at the same time is not before.
Well, when you look at the fact that the statute of limitations is also a prerequisite to suit, that can also happen at the same time.
Well, what we said in Chatha was that that filing an administrative complaint was a prerequisite to suit, not that the general statute of limitations was a prerequisite to suit.
That's right, but since CHAFA, and prior to CHAFA, we have held that general statutes of limitations can be jurisdictional. So for instance, the Clausen BTA, this is a case that I don't think we cited, and I can give you the location. There we said that the statute of limitations was a statutory requirement and a jurisdictional prerequisite to a workman's compensation suit. We also discussed the filing deadline in AC interests and the filing deadline in City of Madisonville v. Sims.
But AC interest said that the service deadline was not a condition precedent to suit, so that seems to cut against your argument.
It did, but the facts in that case were different because there, the service deadline had a specific time after which service could be, or a service of citation could occur.
So if
that's
it's longer, it's jurisdictional, but if it's shorter, it's not?
Well, I would say that if there's some indication that the legislature did not want to fall on the default rule that bringing suit means both timely filing a petition and serving the defendant, then they'll make some kind of indication, such as dealing with service differently than dealing with filing a petition.
So, because the statute 311.03 specifically simply uses the term statutory prerequisite to a suit, and that's jurisdictional, are these, what is your authority that this is prerequisite to suit when it is contrary to what we think of as prerequisite?
If I can answer that in two parts. The first one is just an easier way to think of it, which is without service, you can't bring suit. And so in that way, it's a prerequisite to suit.
Well, you can bring suit, you just have to serve them after you file the lawsuit.
Well, that means that the service is untimely, but you're forgiven because of diligent service, right? Because under Rigo v. Manufacturing and Gant v. De Leon, the idea is you have to show diligence from the time that you file the petition. And so in order for you to...
And if you don't, it gets dismissed, right? It doesn't just evaporate. There's still a suit that the court has to dismiss.
Well, only when it's not a 311.34 issue. So if you look at Prolix v. Wells, for example, in that case, this court said, first of all, look, and this is from 2007, that there's this suit under 16003. It was not timely because a timely filed suit will not interrupt the running of limitations unless the plaintiff exercises due diligence in issuance and service of citation. This court has said that again and again. It said it in Rigo Manufacturing. It also, if you look at CHAFA, it cited with approval this El Paso Independent School District v. Alpinci case in the Court of Appeals of El Paso. The idea that suit requires both of these things is not new. It's something that this court has held even at the time of Mingus.
But it's also not statutory, right?
It's not statutory, but of course what this court does when it's interpreting statutes is look at
Well, if it's not statutory, if it's not a statutory prerequisite to suit, to service, to have service, if that's a constitutional and a rule-based requirement, but not a statutory requirement, then how does it qualify under 311.034?
I think I misunderstood your question. So to the extent that it's not statutory, what I meant was the legislature understands that bringing suit means filing a petition and serving, but it is statutory in that in 101.102, there's a service requirement, and then in 16.003, there's this bringing suit requirement.
But I think what he's saying is that diligence is a court-made rule, right? And so how does that fit into your argument?
I do think that diligence is a court-made rule, but I also think that this court, even with the statute of limitations and notice, treats these particular requirements the way that the court has done in the past, unless the legislature made some indication that that was not acceptable. So for example, actual notice suffices in place of notice. It does so explicitly in the TCA, but then in others, it's just something that the court adopts. I think that the same is how diligent service is treated.
And so my understanding of your position would be that diligence is not itself a statutory prerequisite. It's the statute of limitations that's the statutory prerequisite. And you look to diligence to know whether the statute of limitations has been met.
Yes, I think that's right. The only thing that I would mention, I guess, is that when you look at the language in, I think Prolix v. Wells is a good example, they do say filing the petition and diligent service. So this court has at least put diligent service as, both something from the common law and then obviously
But you don't
something
need to
within the
call,
statute.
we wouldn't need to call diligent service a statutory prerequisite. Because if the statute of limitations is a statutory prerequisite, then diligence is just something that would affect the analysis of whether that statutory prerequisite has been complied with.
Exactly, and that's how this court has approached those types of cases before, so.
Except for Roca Forte, where we said that post-suit notice requirement was not jurisdictional.
Yes, Your Honor, but again, there you have a post-suit notice and.
Well, and here we have post-suit service.
Not necessarily. So first for the post-suit notice, there the statute was explicitly saying after suit, you need to do this notice requirement. And since CHAFA requires as its third component, pre-suit, certainly notice did not apply there. Here, there's nothing in the statute, there's nothing in 31134 that says that service is post-suit. And that's because, as Rigo says, and I can quote there too. Let me see here. So, all right. The mere filing of a suit will not interrupt or toll the running of a statute of limitations. To interrupt this statute, as in to bring suit, which you need to do to meet a statute of limitations, the use of diligence in procuring the issuance and service of citation is required. Another example of that is in Prolix v. Wells. This is from 2007 again. Timely filed suit will not interrupt the running of limitations unless the plaintiff exercises due diligence in the issuance and service of citation.
And without due diligence, the date of service becomes the date you look at to determine whether the statute of limitations has been complied with, because you don't relate back to the date of filing unless you have diligence.
Yes, Your Honor, which is the issue here, right?
Yeah.
Because as a matter of law, Ms. Tanner has not shown due diligence.
Why does this matter? You could just raise it on a motion for summary judgment, right?
We could, but.
And you did, I think.
We did. We raised it in both PTTJ and a motion for summary judgment. I think first it matters because this is what the legislature provided the state for the reasons that are stated in CHAFA. 31134 is a direct response to this court holding that these types of things don't really need to be addressed at these types of procedural requirements don't need to be addressed at this early stage. Right now, when you have these procedural requirements that are something that you only need to investigate jurisdictional facts for, you don't really need to go into the merits. It's a kind of quick look, and you can say, obviously, this is 43 months late. As a matter of law, it is, there's no jurisdiction. The legislature wants to preserve the state's resources and really also the plaintiff's resources.
Well, you could do that with the summary judgment too, and which is demonstrated by the fact that you did.
Well, here it was, I don't want to say lucky, but this is a unique case in that all of that was coming up at the same time. But you could see in a different case that maybe there would be more discovery about diligence that the plaintiff wanted to bring, or there could be
If you
more.
brought it as a summary judgment and the district court denied it, what would happen next?
Can you say the beginning?
If you brought this same claim as you did, both as a plea to the jurisdiction and as a motion for summary judgment, if the district court denied the motion for summary judgment and there was no plea to the jurisdiction, what would happen after that?
Well, I think if the court denied our motion for summary judgment, we would still be before the court on the
Go
merits
through
of
the
it.
merits, full discovery, all that.
Yes,
If it's a
yeah.
plea to the jurisdiction and the court denies it, what happens?
Right, then we're done, which I think is what the legislature wanted.
Well, if it's jurisdictional, you get an interlocutory appeal from the denial.
Exactly.
I
under
mean, that's
5114.
that's why it matters.
Yes.
Because
yes,
if
Your Honor.
whether you file it as a motion for summary judgment or a plea to the jurisdiction, if in fact it's a jurisdictional challenge, then you get an interlocutory appeal.
Yes, Your Honor.
So you seem to be relying on the fact that timely filing of suit in compliance with the statute of limitations would be a statutory prerequisite. But isn't that the suit itself? It seems like it's not a prerequisite. It is the suit when you file your petition and do the service under your hypothetical. It's not a prerequisite. It's the requisite.
I think that, as we discussed a little bit earlier, this is the same issue that comes up with the statute of limitations, which is if you file before the statute of limitations, you filed, right? And so there the suit is brought. But I think the way to think of it, rather than just kind of counting the hours, is to say, well, what is required for you to be able to check the box and say you brought suit? And you can't check the box and say you brought suit if you haven't served. And if you are late serving.
Right, but say we didn't have say they served on the same day they filed, but they filed 1 day late under the statute of limitations. Why would that be failing to comply with a statutory prerequisite to suit?
Because the statute of limitations is a statutory prerequisite. So I think.
Well, but it says you must bring suit.
Yes.
And so you did. But it's not something you have to do before you bring suit. It is the bringing of the suit.
Well, I guess first, the way that this court has interpreted the statute of limitations, and here the court in Chatha actually quoted another case, CJ versus Guard, and that Court of Appeals did say the statute of limitations isn't something that happens before, it happens after. My time is up, can I finish?
Finish your answer.
Okay, but the court said instead, look, you have to file within the statute of limitations in order to bring suit, that it's a requirement of bringing suit.
But that was not the statute of limitations to file the suit that was in the court in Chatha. That was a statute of limitations to file the administrative complaint that was a prerequisite to filing suit. So you see the difference.
I do see the difference, Your Honor, though I think it would have the same effect. But what Chatha also stated was, and I think this is an off-quoted line, but a statutory prerequisite to suit, whether administrative, such as filing a charge of discrimination, or procedural, such as timely filing a lawsuit, is jurisdictional when the defendant is a governmental
Right,
entity.
and that was dicta in that case, because what we were talking about was not the suit, a time in which you had to file the suit that was in the court at that time. It was a time in which you had to file the administrative complaint.
Yes, Your Honor, and I mean, we could dismiss it as dicta, but we also have subsequent cases that have taken the statute of limitations line and run with it.
Any other questions? Thank you, Ms. Cherry. We'll hear from the respondent.
May it please the court, Ms. Holt will present argument for the respondent.
May it please the court. Jurisdiction is a term of profound consequence, and there are drastic substantive ramifications to calling something jurisdictional. When the suit is against the state, that means you increase the number of cases available for interlocutory appeal. It means you take away the ability to raise equitable defenses to a statute of limitations, not just due diligence, but equitable tolling and fraudulent concealment. It also means you contravene this court's policy of not leaving judgments vulnerable to collateral attack.
But those things deal with subject matter jurisdiction, really, right? Not personal jurisdiction.
Well, in this case, the problem with this case is you're straddling the line into subject matter jurisdiction when you look at things like due diligence that require a merits determination. So I do think if you find that a common law equitable requirement like due diligence is a jurisdictional requirement, then you're leaving all of judgments subject to collateral attack later that the court didn't have jurisdiction because there wasn't due diligence, or the court didn't have jurisdiction because there was fraudulent concealment. So you are leaving those what would have been final judgments, you're opening them up to attack because they're always subject to attack on a jurisdictional basis. And what you've done is expanded what you've defined as a jurisdictional basis.
If we agree that this isn't jurisdictional, then, there was a 43-month delay in service. And so wouldn't that negate diligence just as a matter of law?
Well, again, that's a due diligence determination, so that's a merits determination. And if the state had wanted to file, and could have filed a traditional motion for summary judgment, gone about this the old-fashioned way, a summary judgment on the merits, had a merits finding on due diligence, then yes, then this court could be looking at a merits determination of due diligence as a matter of law. But in this case, neither the trial court nor the Court of Appeals made a determination of due diligence. So there's not a due diligence finding for this court to affirm or deny. What this court would have to do if you reach the due diligence question is you either have to decide due diligence is jurisdictional, which would be a sea change in the law, and which would drastically expand what's a statutory prerequisite, or you'd have to, you'd be making a decision on the merits. You'd be.
Well, no, it seems to me that the question is whether statutes of limitation are statutory prerequisites. And Chatha says they are, and perhaps you need the court to say that that's dicta and we didn't really mean it in order to prevail.
I think Chatha has been expanded. Right now, some of the courts of appeals are saying that what Chatha said is a statute of limitation is jurisdictional, but actually what Chatha said, its primary holding was we're not going to look at another law like the Ledbetter Act and incorporate it into the Texas statute. We're going to stick with the Texas statute. Now, within the confines of the TCHRA, because we're not going to go grab things like, in this case, it would be go grab a statute of limitations. So within the confines of the TCHRA, how do we determine what are the statutory prerequisites? And now we have a three-part test. And now, this particular requirement, the 1603 statute of limitations and due diligence, neither one of those passed the Chatha test.
How do we decide whether we should confine ourselves to within the context of the TCHRA to decide what the prerequisites are versus looking at the whole statute, all the statutes?
I think 311.034 is explicit and exactly the answer. 311.034 is the state's basis for saying, well, you have to go find a statute, so we found a statute. But 311.034 deals only with a waiver of sovereign immunity, and how do you construe statutes that waive sovereign immunity? 16003 is not a statute that waives sovereign immunity. So the government code 311.034, it doesn't tell us how to construe 16003. The common law and the courts tell us how to construe 16003.
So the legislature passed 311.034 in the wake of the court's decision in Lautzenheiser. And in that case, we held many notice provisions are not jurisdictional, raising the same considerations that you raised in your introduction. But at least for suits against the government, the legislature has abrogated that holding through 311.034. What are we to make of it in construing it, given that we had held that prerequisites are not jurisdictional, and then the legislature came back and said, well, in cases against the government, they're going to be?
Because 311.034 only abrogated it in terms of statutory prerequisites that were contained in the statute. The legislature is presumed to know the common law and to know that for 200 years, statutes of limitation have not been jurisdictional.
They're defenses.
They're defenses. And so the court is to presume that when the legislature used the phrase statutory prerequisites in suits waiving government immunity, that they weren't talking about things like statutes of limitation. We're to presume that the legislature doesn't displace common law unless they specifically tell us that they're doing it. And in this case, if you want to expand 311.034 and this jurisdictional definition out to things like 1603 or anything else, by the way, anything else that happens to be codified in the state of Texas, a plaintiff can no longer look, if this court adopts the state's holding, a plaintiff can no longer look within the confines of the Tort Claims Act to figure out how to bring a tort claims case. They have to scour the common law to find out what else maybe extra statutorily glommed onto a tort claims case that, by the way, they've got to do that. Not only do
Well,
they
the
have
the
to
only
do it.
result of this case would be that you'd have to comply with the statute of limitations, and if they think you haven't, they can take an interlocutory appeal, which just doesn't seem like a very big deal, honestly, like in this, given the scope of all these interlocutory appeals we have in these cases against the state. I mean, statute of limitations is usually a pretty, fairly clean legal issue and amenable to an interlocutory appeal, and I'm not seeing a whole lot of practical negative consequence to this being appealable.
I think that practical negative consequence is actually exactly what you alluded to, that everything that we call jurisdictional will now be subject to an interlocutory appeal. And not only what we call jurisdictional, but the common law defenses to what we call jurisdictional, those are equity-based arguments, those are merits-based arguments. Was there fraudulent, a statute of limitations can sometimes be an easy call, which is why why they're often determined on summary judgment. And that's the proper procedure for a statute of limitations. Jurisdiction can also be straightforward. You look at the statute and did you comply with the statute? But there are times.
My point is, when you're litigating against the state, there are just all kinds of things that are normally summary judgment that end up being appealable and a plea to the jurisdiction. And if statute of limitations is treated like one of those, it just doesn't, I don't know that it adds a whole lot to the mix, given all the other things they can appeal as jurisdictional under the law we have on sovereign immunity.
I think you're right. And if this court isn't concerned about how many interlocutory appeals we have, and you're not concerned about opening the floodgates of additional interlocutory appeals, then there would be no problem with the state's suggestion that we call this also jurisdictional and we lump it in and we have one more thing that we're going to allow to be appealed on an interlocutory basis. I don't think that's what the government code even meant when they codified this, what either of them meant. The interlocutory appeal just says in states against a government, jurisdictional issues can be brought up on interlocutory appeal. Well, all suits against a government are going to be based on a statute. And then 311 says, if you want to know what the statutory requirements are, which of those are jurisdictional, then you go look at the statute. It's a closed system. You never get outside of the statute, the interlocutory appeal, and the government code.
So your argument would be different if there were a particular statute of limitations within the particular statute. How? Maybe you can explain it. Is if it were within the Texas Tort Claims Act, your position would be different?
It would be very different. Because the legislature is the one who defines the waiver of sovereign immunity. And so the legislature puts in the Tort Claims Act, and they have, in the Labor Code, in the Health and Safety Code, when the legislature wants a statute of limitation to be a statutory prerequisite, they put it in statute.
And it wouldn't need to be worded any differently, it would just...
I don't think it needs to be worded any differently. I think that the Chatha test, the number one requirement, which the court thought at the time was obvious, is that a statutory requirement has to be in the relevant statutory language. And I think that that's the wording that answers that question of you go look at the relevant statutory language, and in a labor code claim, that's the labor code. And in a tort claims case, that's the Tort Claims Act. So we stick to, otherwise relevant means nothing, and otherwise statutory prerequisite means nothing. As the court noted, we know why the legislature passed 311-034. They were specifically responding to Lutzenheiser, and they used the phrase statutory prerequisites that the court had used in Lutzenheiser in Dubai. If what they actually meant was apply the common law, apply due diligence, ask about equitable tolling, then the use of the phrase statutory prerequisite loses all of its meaning. They didn't say all common law requirements are jurisdictional.
Right, but if the statute of limitations was in the Tort Claims Act section about this kind of claim, you would still have all those questions about diligence and equitable tolling that would get litigated, and it seems that you're saying would be jurisdictional if they were in a different code section.
I think you would not, Your Honor. I think when the statute of limitations is inside the statute, then a basic tenet of sovereign immunity is you don't have those equitable defenses. That's why it's such a big deal that we have it in the statute or we don't.
But you'd have diligence at least. I mean, diligence is just an analysis that goes into the question of whether the statute of limitations has been complied with. It's one of many different issues people might raise on that question, and surely all of those are in play, no matter what code section the statute of limitations is contained in.
2 points. Diligence is a common law interpretation of 16003. It doesn't, that's where it comes from. And I don't think it applies. Justice Lerman's dissent in Chatha specifically addressed that issue. Was the problem is, if we call this a statute of limitation, if we call this statute of limitation jurisdictional, one of the effects is we're losing all those equitable defenses, because those equitable defenses are no longer at play in sovereign immunity. That's a basic tenet of sovereign immunity, is when the state's immune, they're immune. You can't come in and raise a bunch of defenses. And so I do believe that we're losing the ability, if what you want to do is bring general statutes of limitation into the Tort Claims Act, then either you have to leave all of those.
It could be that the converse is true, that if a common law exception to the application of a statute is part and parcel of the analysis of whether the statute applies, that doesn't exclude it from consideration in applying the statute under a particular set of facts, but it also doesn't remove any jurisdictional implications that attach to it.
And I think that's true when you're statutory construction. If what you're construing is use or operation of a motor vehicle under the Tort Claims Act, but there's no, if you're construing a term in the statute, then you can go to the common law to see what that term means, but there's no term in the statute that anyone's construing. The Tort Claims Act doesn't have a statute of limitations. Even if we go to 1603.
What's your response to the state's argument that the service requirement is in 101, 102 of the Tort Claims Act, and so that's a statutory prerequisite?
So 101, 102 just says that there's liability to the extent that there would be, that the employee would be liable under Texas law. And first of all, I think that's a question of immunity from liability and not a question of immunity from suit, which would be the jurisdictional basis. And that does, if what we're talking about is a defense to liability, 101, 102 allows the state to raise their defenses to liability. Those are merits-based. That can be held on a summary judgment. Just because that's liability, Texas law and liability become elements of the cause of action, you have to find liability in Texas law. That doesn't also elevate them to the level of jurisdictional requirements. What the legislature specifically said in the government code is there's a difference. Statutory prerequisites are going to be jurisdictional, not common law interpretation is going to be jurisdictional. So you still apply it, you still construe it, you still do the analysis, but you don't raise it to the level of jurisdiction.
Do you think that bring suit means something other than file suit plus timely service?
I think under 1603, that bring suit, at this point in our jurisprudence, that bring suit means both sue timely and serve diligently. But in 311...
The diligent part of that benefits who? The diligence. Filing in the courthouse and serving timely or diligently, which I think Justice Bland's point is that diligence really can be a way of understanding, did you comply with the service timely? Is it timely service? Well, it was because it was diligent. Who does that diligence aspect benefit every single time? It's the plaintiff, right? We could just say it's filing in the courthouse and service within the period of the statute of limitations period. No diligence aspect of that at all. That could be the law.
I think that is the law with respect to statutory prerequisites because they're jurisdictional.
All right, so that's, your position is that if we were to conclude that bring suit is the jurisdictional term and that it means filing in the courthouse and service, that if it's jurisdictional, that diligence is out of the picture and there's no ability of the plaintiff to say, oh, no, it was timely because I was diligent in my efforts to serve. Is that your position?
Only if where you're getting that phrase bring suit is from a statute of limitations that's within a code that we're construing under 311.034. If it's a tort claim, if it's a slip and fall claim, then... Well,
it's in 16.003. A person must bring suit, skip to the end, not later than 2 years after the day the cause of action accrues. And so if diligence is out of the question, if it's jurisdictional, that means that the case is over. right? I mean, clearly, service was not timely, if that's what we mean. If diligence is baked into the notion of service, then we have a whole nother question, and all we're trying to decide is whether or not that phrase "bring suit," by being incorporated into the Tort Claims Act, constitutes a prerequisite to suit.
I agree. Yes, that's a danger. The danger is if you bring 16003 into the Tort Claims Act, then you lose the due diligence as a defense. That is what the dissent in Chatha said would happen.
But does it have to happen that way? That seems like a rather high-stakes position. It doesn't, I mean...
The only way it does, I think it is high stakes, because I think for 200 years, statutes of limitations have not been jurisdictional. And one of the reasons that they're not jurisdictional is because we want to ask questions of equity, and we want to ask these defenses. And we will continue to do that unless and until the legislature makes it a statutory prerequisite. And they know how to do that. They just write it into the enabling statute.
Well, and also defendants can waive the statute of limitations.
It can be waived, absolutely. So it is not a requirement.
Or forfeited if it's not timely raised, if it's a general statute of limitations.
Right.
But not if it's in the Labor Code or the Tort Claims Act, is your position.
Correct. If the court finds that it's both jurisdictional, and mandatory requirement, in AC interest, the court decided that service was not jurisdictional and was also not mandatory. So you could potentially, get into the analysis of, aside from the jurisdictional question, is it a mandatory or a directory provision?
By granting the plea to the jurisdiction, did the district court not necessarily find that diligence was not met?
Well,
I hear your argument, which seems extreme to me, that diligence is just irrelevant to it, but that doesn't seem to be what the lower courts have understood it to be. So I'm trying to figure out if there's any difference between granting the plea to the jurisdiction and finding all the things that would be necessary to have granted summary judgment if we decide that it is not jurisdictional, but summary judgment is on the table.
Well, again, the very big difference is that under statutes of summary judgments are different. Summary judgments are merit-based decisions made by a trial court or a court of appeals. In this case, they both explicitly decline to weigh in on the merits of due diligence. So if this court does it today...
Did the district court, that's what I'm trying to figure out, did the district court's plea to the jurisdiction really not necessarily reach the question of due diligence? If the district court had concluded that due diligence had been satisfied, would it have granted the plea to the jurisdiction?
I agree, and if you affirm the district court's decision, then you will also be ruling that due diligence is a jurisdictional requirement. So if that's the path that this court wants to go, first include 16003, because you have to start there, and then include the interpretation of 1603 that requires diligent service. If we include all that as a jurisdictional prerequisite, then yes, you can grant the plea to the jurisdiction, and you will have made that finding.
I'm saying suppose we don't want to call it a plea to the jurisdiction, we just want to deal with it as a summary judgment question. Did the district court's finding on the plea to the jurisdiction not necessarily give us all that we need to know about the district court's view of diligence?
I don't think so. I understand the appeal of making that decision on the merits. I think because there isn't a judgment on diligence that this court can either affirm or reverse, I think the proper path has to be that you take it back to the trial court and say, now decide it on the merits of due diligence, and we know what likely they will decide, but at that point, that will be the trial court making a merits-based summary judgment determination. No one will be making a jurisdictional determination.
Are you arguing that the summary judgment finding could not properly be before us now based on that procedural argument, or are you arguing that there actually is some fact question about diligence that hasn't been resolved, needs to be resolved, or a combination of those?
We did respond to the summary judgment, and we argue that there is a fact question, so I do believe that there is a fact question. But again, this court's not answering a fact question on diligence unless you've decided that it's a jurisdictional statutory prerequisite. So if you don't want to go that far and decide due diligence, because this court's limited to jurisdictional, not merits-based decisions.
Well, if it's jurisdictional, but there's a fact question about it, that would also stop us from being able to just get rid of the case now. So either way, it seems to me that either it's a matter of law that diligence has not been established, if we think that diligence is relevant even in the jurisdictional context. Or it's a fact question. And do you, Chief, would it be okay just take a brief moment and tell us what the fact question you really think is?
Well,
I'm sure your friend on the other side will tell us why it's a matter of law that she could win either way.
Just remember that if you make that determination as jurisdictional, then you've allowed interlocutory appeals anytime anybody wants to.
I understand.
question due
What's the
diligence.
fact question about diligence?
The fact question is whether an ordinarily prudent person in the circumstances exercised diligence. And as this plaintiff put to the choices that she was put to under the election of remedies in 101, 106 of the Tort Claims Act, was she reasonably prudent? Was that a reasonably prudent cause of action, given what she did, and then given the responses that unfortunately the state, the length of time, and their strategy decisions, both sides were using the election of remedies in the Tort Claims Act 106 to try to figure out who the proper defendant was. And there's a fact question of whether she reasonably sued and served the defendants in the order that she did at the time that she did. I could go into the details of the facts, but that's the summary of the factual argument, is that whether or not she used due diligence within the context of the Tort Claims Act that she was limited to for electing a remedy between suing a state employer and suing an employee.
Any other questions? Thank you, Ms. Holt. Ms. Cherry, you have 5 minutes.
Thank you. If I can just address some of the questions that the court asked. I think that the first one is this idea of what exactly is in 101, 102. One of the points that we haven't emphasized, just because it's a title, so it's more of a clue than a conclusion, is the fact that that provision, which is about venue and service, is actually called commencement of suit. And while the title of a particular provision isn't determinative, I think that here, if you're looking for signs about what the legislature was thinking about, I think one of the things that they were thinking about was the fact that here are things that have to do with the commencement of suit, right? Venue, service. Another thing, or another issue, was this whole location issue. First of all, Chatha was citing Colquitt. Colquitt is a case about where the notice requirement only required a certain amount of months after the accident. The plaintiff brought their petition before those months expired, and the court found that actually notice had to be brought before the petition was filed. And so this court held you can't add things to a statute that aren't there. So it wasn't about, this is in the wrong location. It was about, is this something that the legislature actually said? And another point, and I don't really want to go into a parade of horribles, but do we think that the fact that Chatha used the term the statute meant that the legislature meant to exclude all of the statute of limitations in Chapter 16 from the scope of 31134? I mean, that
Well, you
seems...
don't really have to pick very far in Chatha to see that it says these are things that must be accomplished prior to filing suit.
Yes,
And
Your Honor.
service is not something you accomplish prior to filing suit.
I still think that the way that this court has been dealing with service draws the other conclusion, which is that...
That service happens before you file the petition?
No, but filing the petition is not filing suit.
Well, but you're saying filing suit is filing the petition and service.
Yes, Your Honor.
Okay, so how does the service happen prior to filing the petition and the service? That doesn't make any sense, because the service can't happen before the service.
No, that doesn't make any sense. Maybe I can draw you back to the TCA. So if the legislature is calling 101, 102 commencement of suit, then there has to be, I think, some understanding that this isn't something that's after the suit, that when you serve someone, that's required for the suit. I think the same thing has to do with the venue provision.
That is the suit, in other words. The service is part and parcel of the suit.
The service is not the suit.
I'm sorry. I thought you said the service was part of bringing suit.
I'm sorry, yeah, part of bringing suit. It's not, I don't want to imply that if you just serve someone that you've brought suit.
It seems like it's either got to be part of it or not, and it can't be part of it for one purpose and not for the other. That's where I'm getting confused with your argument.
Let me know if I can try to rephrase, but things that are required in order for you to bring suit are not post-filing suit. And so here, serving citation is one of the things that's required to stop the statute of limitations. And if you haven't stopped the statute of limitations, then you haven't brought suit.
So prior to, we should just ignore that Chadha says prior to.
I don't think so. And one of the reasons that we can that we don't necessarily need to ignore it is the cite to USAA. That was another case about a statutory prerequisite to suit. Also, I think that Chadha cited. I'm sorry, but also I think that if you look at Mingus, where all of this started back in 1926, Mingus talks about a lot of the jurisdictional prerequisite proceedings, which would be that determine the jurisdiction of the trial court to hear, and they list the giving of notice of intention not to abide by an award within 20 days from the date of the same, the filing of proper suit within 20 days from the date of service of such notice. These are all being jurisdictional facts and essential to concur before jurisdiction would attach. So if, as this court said in Chadha, the legislature was just reenacting Mingus, then it was also reenacting all of the concerns that are in Mingus.
I just want to make sure I understand so I understand it's your position that a statute of limitations, when raised by a governmental body as the defendant, is a statutory prerequisite, a requirement to file suit or to bring suit before the statute of limitations expires is a statutory prerequisite to suit for purposes of 311.
Yes, Your Honor.
And are you saying Chadha held that?
Yes, Your Honor, it did.
But Chadha was dealing with the complaint filed with the administrative agency.
That's right, and I don't mean to interrupt, but
No.
Yes, that's right. But Chadha also says explicitly that it's not only thinking about these administrative requirements, but also these statutory requirements, such as statutes of limitations. And the case that Chadha disagrees with, that TDCJ the Guard case, that's a case where the court said, look, statute of limitations doesn't come before filing suit. And the court said that they disagree with those courts of appeals, that approach by courts of appeals. So it seems that the Chadha court was clearly thinking about statutes of limitations and clearly finding that the act of filing one, or I guess we could say the timing of it, is a prerequisite to suit, that if you haven't met the statute of limitations requirement, then you haven't brought suit.
Did you want to give us the citation to the Clausen case that you
yes.
mentioned might be relevant?
Sure. The citation is 475 SW 2nd 735.
Any other questions? Thank you, Ms. Cherry. The case is submitted, and the court will take a brief recess.